Welcome to today's program titled Issue Spotting, Litigation Trends in the Post-COVID-19 World. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Lisa Damon.
Thanks so much, and welcome everyone. We're really delighted to have you all here. Thanks especially to the ACC Northeast for their sponsorship today. We've had the honor of being associated with the ACC Northeast for many years and appreciate their leadership in our community. And welcome especially to all of you who are members, and to those of you who are not yet members, we strongly suggest that you consider joining what is really a tremendous organization. So let me turn briefly to the agenda for today. We're all very excited to be here. We're going to try and move at a pretty fast clip. One of the things we try to do at Seyfarth is to stay ahead of the curve, to look down the road and understand what's coming. That was the impetus for today's program. We've assembled what we think is a great team, and in a very fast hour, we're going to give you the landscape on the coming claims and, as importantly, mitigation tactics you might want to employ now to stay in front of the issues. Seyfarth is monitoring the COVID litigation filed across the country, and you probably would be interested to know that there are already 800 reported lawsuits filed where COVID-19 is a triggering event. They cross specialty areas, but we're clearly seeing a wave of litigation. With that in mind, the agenda you have in front of you covers that landscape. We're going to offer to follow up with any of you if you need more in-depth information, or if a discussion is better, just let us know. As Crystal said, the text box, the chat box, please feel free to use it. Let us know if you need more information or would like a follow-up. So now let me just briefly introduce the team that we have today. You're going to hear first from Brandon Bigelow. Brandon's a partner in our commercial litigation practice in Boston, and he's going to kick it off by talking about issues in commercial litigation. Chris Robertson will go next and discuss whistleblower claims. Chris is the chair of the firm's whistleblower practice and a former senior counsel with the Division of Enforcement at the SEC. After Chris, we'll hear from Patrick Joyce. Patrick is a member of the firm's catastrophe response team, a team that we've relied on probably too heavily in the last 2 months. Patrick has led many of our largest clients through complex OSHA issues and will address OSHA and the coming litigation in that area. And then Lynn and I will follow up and round out the hour by talking about employment claims. Lynn, who chairs our trial group, will also spend a few minutes addressing the changes in trial practice as a result of the times we're in, including implications on future jury pools. So we're on a tight schedule. I'm going to turn it over right away to Brandon. Brandon, all yours.
Thanks, Lisa. So why don't we start with some good news? I'm sure we can all use that. Civil filings in federal court are down 22% for the 4-week period ended April 12, 2020, and down 22% for filings during the same period last year. So that's the good news. It's very difficult for litigators to litigate right now. We're finding ways to move forward, thank goodness for electronic filing and whatnot, but certainly litigation activity right now is down. Now the bad news. I like this quote from Randy Mastro at Gibson Dunn. I don't want to say a tsunami, but do I think there will be a lot of litigation that comes out of all this? Yes, without doubt there will be. Later this year, litigators will be busier than ever. And although that's good news for me and my colleagues here at the Litigation Department of Seyfarth Shaw, obviously for all of you, you want to be avoiding litigation where you can. Where do we think the most commercial litigation pressure is going to come from? Well, supply chain and cash flow disruptions are obviously going to put a lot of pressure on businesses and likely to lead to significant commercial litigation. There are also some unique challenges that have been presented specifically by the response to the COVID-19 pandemic, and I'll go through those a little bit further on. So first, I want to talk about force majeure, impossibility, and the UCC battle of the forms. Remember those? They have come roaring to the forefront in the last 2 months and are likely to dominate commercial litigation for the next year or so. Those supply chain and cash flow disruptions I was talking about are going to force us to focus a lot more on our contractual relationships. If you are a manufacturer who supplies products to customers, or if you are a customer who buys and resells those products at retail, then you are likely to find a crunch, either because somebody who makes something for you that you sell isn't available, or because something that you make requires an input that isn't available. Force majeure clauses are contractual allocations of risk. You'll find those in contracts. They're often, but not always, in contracts that take into account the possibility of an act of God or other specified sort of disaster that's really beyond the control of the parties. Not every contract has a force majeure clause. For example, I was just reading that the NFL Players Association, the CBA agreement, does not actually contain a force majeure clause, which is going to create tremendous difficulty for the NFL. Even if a contract doesn't have a force majeure clause, there is a common law doctrine of impossibility, also called impracticability or frustration of purpose. That doctrine can be used by parties to excuse or delay performance because of the occurrence of an event that makes performance impossible, and again, for which no party is at fault. And none of us are really at fault for the current coronavirus pandemic. Now, finally, and with respect to the sale of goods, I wanted to talk briefly about the battle of the forms. Under the UCC, Section 22072, where there's a conflict between a purchase order and acknowledgement, any additional terms are considered proposals for addition to the contract. And between merchants, they become part of the contract unless the offer expressly limits acceptance to the terms of the offer, material alters it, or notification of objection has already been given or is given within a reasonable time after notice is received. Now, why is that important? Well, first, let's talk about the kinds of litigation trends we're seeing. The states and cities have responded dramatically to the COVID-19 crisis. So, for example, there have been laws and regulations that have excused performance of certain contract obligations, like, for example, paying rent, prohibiting certain activities, like, for example, collecting debts, or requiring insurers to cover COVID-19 claims under property insurance policies. Now, these regulations, however well-intended, raise significant constitutional issues, and it's likely we'll see lawsuits challenging those actions. They've already been filed and are likely to continue to be filed over time. Already, class action lawsuits have been filed against the airlines, for example, for refusing to refund airfares for flights that don't fly, health clubs for charging fees for memberships that customers cannot use, and banks for refusing to give SBA loans to borrowers who are not already customers. State attorneys general are pursuing complaints about price gouging. I think I was reading that between the FTC and the states, there have been something on the order of 20,000 or 30,000 complaints that they've been fielded already under state laws and regulations that prohibit significant price increases during times of emergency. And we are seeing private plaintiffs following suit by filing class actions against Amazon and others. For example, a complaint was recently filed in federal court in California alleging that the price of eggs went up 30% in the immediate weeks following the outbreak of the COVID-19 pandemic. So what can you do to mitigate your risks during these times? Well, first, I encourage you to read and reread your insurance policies and engage outside counsel where needed to determine whether you have a claim for a COVID-19 related business disruption. And if you're an insurer, no doubt you're already talking internally and hopefully externally to counsel about how to respond to these state laws declaring COVID-19 to be an insurable event. You should be reading and rereading your contracts with suppliers and customers and engaging outside counsel where needed so you know what your business's rights, obligations, and exposure are from ambiguities. I was talking earlier about the battle of the, well, I'll get to that in a minute. You should also engage with your business team to make sure they're using best practices when contracting and to identify the potential sources of disruption that are going to arise from suppliers, customers, creditors, and debtor relationships. I was mentioning the battle of forms a moment ago. We are seeing already instances in which where there's been a breakdown of some kind in a supplier-customer relationship, and where usually the business folks can smooth it over with some grease, they just give or take a little bit on the next transaction. Now that supply is less certain and cash is less available, people are starting to insist more on the express terms of their purchase orders or their acknowledgement forms. And what we're seeing is a lot of dispute and confusion about what terms actually apply in the relationship between suppliers and customers. You want to make sure that your business team understands the process by which orders are taken in and by which and are accepted, so that you know what the terms, the payment terms are going to be for products you sell or products you buy, and what the remedies are going to be if the product can't be delivered or can't be received. Now, finally, although I'm a litigator and I encourage litigation where appropriate, you'd be asking yourself, is litigation avoidance actually the best response? The ABA Business Law section has actually published a fine form COVID-19 standstill tolling agreement, which is available at the URL that we've set forth here. There are instances where, as Winston Churchill would say, to jaw is better than to war, and you should consider whether when you run into a dispute with a supplier or a customer, consider whether a negotiated resolution at the front is better than having litigation on the back end. With that, I will turn it over to Chris.
Thanks, Brandon. Appreciate it, and thanks to the ACC New England for sponsoring this. I'm going to talk briefly about whistleblower claims, but what I'm going to talk about will gel a little bit with what Patrick's going to talk about after me. What we wanted to talk about was OSHA whistleblowing, and then also financial whistleblowing, and touch on these subjects, because that is where we see, certainly from the plaintiff's side, we see a lot of activity on the plaintiff's bar, putting out press releases, putting out feelers into the market to invite whistleblowers to reach out to them as counsel about a variety of claims. But what we're going to focus on between Patrick and I are largely workplace safety, and then I'll focus on financial fraud related to the CARES Act and other programs that are obviously providing government money to businesses to keep their operations going while we address this COVID-19 pandemic. But very quickly, a lot of people don't appreciate that while OSHA Workplace Safety Section 11C prohibits employers from retaliating against employees for workplace safety issues, in addition to that, OSHA also enforces over 20 other industry-specific federal laws, including financial fraud, Sarbanes-Oxley, airlines, commercial carriers, all sorts of different aspects of workplace environment and whistleblowing. In several new cases that we've recently received where I've had to reach out personally and interact with OSHA, they have, in different calls, said they are completely overwhelmed. They are effectively triaging cases because they simply cannot handle the volume of cases that are coming in. And at this point, they're putting in primary emphasis on workplace safety issues, back to work issues, some of which Patrick will talk about in a little bit. But we, much like Brandon said, where we expect there will be a wave in the late summer and fall, we think the other aspects of whistleblowing and whistleblower litigation, retaliation litigation, and government investigations will start to really ramp up late in the summer and into the fall as the funds that have been provided by the government begin to get used by companies, and ostensibly whistleblowers will come forward arguing that either the money was obtained fraudulently or falsely, or it was misused. Next slide. So what I'm going to focus on is the False Claims Act, which would apply. There is, I will say, I read as early as, this maybe an hour before this call that several plaintiffs' law firms are actually currently lobbying Congress to add into subsequent amendments to the CARES Act or other financial programs, retaliation provisions for against retaliating against whistleblowers if they come forward. There are currently none of those provisions in the current acts, but they are lobbying for them. So whistleblowers would be looking to other statutes, other existing statutes, in order to find anti-retaliation provisions. But I do suspect we will see some anti-retaliation legislation coming out of this within the next, several rounds. I think everyone agrees we're probably not done with what the government's going to need to do over the next few months in terms of financial support. And so I suspect we'll see amendments to some of the current statutes that will include whistleblower retaliation provisions. But let's focus on the False Claims Act quickly. The CARES Act financial relief would be subject to the False Claims Act. The False Claims Act prohibits any false claim to the government where the government hands you money. So that could be a government contract, that could be the loan programs, it could be anything where the government is giving funds. If you have obtained those funds under a false pretense, a false claim, or subsequently misuse those funds so that the claims you made about how the funds would be used are misrepresented, those could result in potential False Claims Act liability. And we have a model we can look to, which was the stimulus that came out of the 2008-2009 recession. We saw that the DOJ back in 2008 established a task force in connection with the mortgage and lending programs. They have set up similar task force with regard to the CARES Act. We all know that there was an oversight committee established as part of the CARES Act, but in addition to that, the House of Representatives has an oversight committee to combat fraud, and a number of government officials have come out specifically to invite whistleblowers to come forward if they feel that there's been fraud in any of these government programs or a fraudulent use of funds or a fraudulent application for funds. So both Congress, the Department of Justice, and private plaintiffs' lawyers are all out there inviting employees to come forward if they think there's something improper happening with any money that's been provided by the government. So employees, they may be particularly sensitive to the fact that this money, at least how it's been pitched out there, and we've already seen some criticisms, and we've even seen some companies return money back to the government rather than, face what they, I think, expected could be these types of claims. There is an assumption by employees that this money is intended to help them with their wages, to help them with their benefits, to help keep these employers viable so that they can come back to work. So there could be a particular sensitivity on the part of employees if they view money being misused or misappropriated in some way or not used for what they think it should be used for. And very quickly, there's a financial incentive for whistleblowers because any recoveries that they would be part of instigating, they can get up to 30% of that. So if you look at the numbers above, about $6 billion that came out of the 2008 crisis, you can do the math. There's real money there for whistleblowers and plaintiffs' counsel to try to recover if they feel that there's been some improper conduct. So what are some best practices that you can implement? You should be reviewing your whistleblower policies. You should be reviewing your code of conduct to make sure it covers receipt of government money. A lot of codes of conduct, they talk about fraud generally, but you may want to look and see if you should have specific provisions or regarding any of the loan programs or money that's coming in from the government. You should remind employees that they can report fraud. Part of what can be looked at in hindsight as a negative is if you may have policies, but you're not adequately training or making those policies visible to employees. Reinforce your anti-retaliation policies regarding any employees that might come forward. And they have several of these task forces have made very clear that they are going to come down very hard on employers if they feel that they've retaliated against employees or tried to keep employees quiet about these issues. And then to the extent reports are made, it's critical that you have a comprehensive investigation of those allegations, good documentation, a good record and conclusions. Employees, and we know this not just anecdotally from statistics, are far more likely to keep something in-house and not go externally, not go to the government, not go to others or a plaintiff's lawyer or whomever, if they feel that the company is taking this seriously and taking their complaint seriously and investigating it seriously. So you can't always go back to the employee with the results of your investigation, but if you can let them know that you're taking it seriously and give them some indication of that the investigation is moving forward and it's credible, that will go a long way to keeping the issue in-house and not having them go externally, where you lose control of your ability to investigate and come to the conclusions regarding the issues. And to the extent improper conduct is found, you have to discipline those responsible. Sometimes that can be a very hard thing. You know, the people that are most, maybe particularly in this environment, who may be most involved in the ability to bring funds in from the government or to work with banks, work with your lenders, they may be the ones who are found to have acted inappropriately. And notwithstanding how painful it can be for a business to remove somebody who's so critical to what they're trying to do, the consequences for not doing that can be far more serious, both from a liability standpoint and from the government. Documentation, again, is critical. And then be aware that whistleblower issues, may be implicated by broader employment decisions. So you want to make sure there's good communication going on within the organization. If you're going to have some broader, in terms of either bringing employees back, making RIFs, any kind of employee that could be adverse employment action, to the extent that there are known whistleblowers or there might be whistleblowers who are known to certain management, communication is key so that they aren't put in a position where even unwittingly you may have retaliated against them and they make a claim, because you're going to want to document that and try to put yourself in the best position to rebut any claim that a particular employee was treated differently because they were engaged in whistleblowing activity. And I'll quickly return to work on whistleblower claims. I'm largely going to turn this over to Patrick, but I just want to be cognizant of the fact that not only laying employees off could raise these issues, but also in terms of bringing employees back. And with that, I'll turn this over to Patrick.
All right, thanks, Chris. I really appreciate everybody being on the call today. And as we've all been hearing over just the last 2 or 3 days, states are starting to think about reopening things. Now, some of you maybe have been classified as essential businesses, so you've still been working, or some of you may be thinking about coming back to work. So this return to work issue is really, really the key, and health and safety is one of those subsections of return to work. Now, if you're still working and you are currently working, these tips and tricks will still work for you. So if an employee is being told they need to come back to work and they have a fear that they're going to contract COVID in the workplace, is that fear reasonable, is the question when it comes to whistleblower claims. And as Chris mentioned, 11C, as you guys probably know it from the OSHA Act. If the fear is reasonable, then that may qualify as a protected activity. And if you've taken any sort of adverse action against them, not just laying them off, but demoting them or disciplining them in pretty much any way, then they may have a valid whistleblower claim. A lot of the steps I'm going to talk about in my next few slides have to do with making sure the fear is not reasonable. And what OSHA has come out with in its guidance is that if an employer is following guidance from the CDC, the WHO, the federal government, state, local governments, whatever it might be, if they're following that guidance and they are making a good faith effort to keep their employees safe if you're still working, or to bring back employees in a safe manner, that individual's fear of coming back may not be reasonable unless they can show that there is, maybe you have a specific outbreak in a facility and you're trying your best, you're doing all the steps, but you just can't contain it, which we have unfortunately seen in some spots. So if the employer is able to take those safety measures to protect the employees, that are set forth by government, it's going to be an uphill battle for an employee to claim a whistleblower protection. And I'm going to get into some of those tips and tricks right now. When it comes to OSHA health and safety, it's usually aimed, well, it is aimed at the employees that you control. It's not really aimed at the public or folks who may be coming in, but a lot of these considerations that we're seeing from local governments are also instructing employers to keep the public safe. So to the extent that there's some interplay between those two, it's possible that OSHA may come in and help out in those situations and do an investigation, or they might call in another agency, such as in Illinois. We've seen interaction between OSHA and the Attorney General's office, where they've kind of been tipping each other off as to, hey, you might want to go check out this retailer that's open to make sure they're protecting the public, or vice versa, make sure they're protecting their employees. So OSHA has put a lot of good guidance out about this. The main thing you need to start off with when you're thinking about bringing employees back is to identify the risk at your particular workplace. Take a look at what you do, who you interact with. Are you open to the public? Are you not open to the public? What types of jobs are you doing? So I have these categories here: very high, high, medium, low. Very high and high are situations where you're in a healthcare industry, or you're in a laboratory setting where you are expected as part of your work to come into contact with COVID. If you're in a medium or a low, it's a situation where maybe you're not open to the public. You are maybe a warehouse that has, it's a gigantic warehouse with only 5 or 10 employees in it. That might be medium or low. Once you've identified your risk levels, identify any sort of measures that you might be able to take to protect your employees, whether it's just reminding them about washing hands or social distancing. If you're in a situation where you have a production line and you cannot physically separate people by more than 6 feet, we've seen a lot of people put up plexiglass barrier guards in between workstations so that even though the distancing can't happen, you cannot pass any sort of infection back and forth. There's also administrative controls like changing up shifts so that you don't have everybody coming into the workplace at the same time. You have one shift leave with enough time to have everybody gone and then bring the next set of shifts in. There's also a lot of jurisdictions and states that are requiring employers to provide their employees with face masks, face coverings. I'm not talking about respirators. I'm not talking about even N95s. I'm talking about a cloth face covering. If it's required in your jurisdiction, you absolutely have to do it, right? If you can't find it, you can allow an employee to bring it in on their own as long as it meets the requirements. Now, if it is considered to be required in your jurisdiction and it's for your employees' protection, you have to determine whether it's personal protective equipment, which is specifically regulated under OSHA, and you have to train and educate your employees how to use it. There's a lot of good guidance on CDC's and OSHA's website as to how to do that, and I don't have, unfortunately, enough time to go through all of the points that you would have to consider on that, so please reach out to us if you have any questions or concerns about whether what you're providing is PPE or not. A lot of people have been asking, well, when I bring my employees back, how do I know if they're sick, right? How do I know if I need to continue to keep them out of the workplace? A lot of recommendations have started to come out from CDC and from EEOC about establishing a questionnaire to determine whether an employee is sick, if they're showing symptoms, if they've traveled, and if they've been exposed or potentially exposed to COVID. Michigan, for example, has decided that they want to be the leader in this. And a lot of their counties have said, you have to ask these questions when you have employees come in. So be aware of those jurisdictional requirements, which we can absolutely help you out with. A lot of employers are asking, should I provide temperature checks as the employees come in? Should I even do COVID testing if I have the resources to do so? Just yesterday, EEOC came out with an update to their FAQs saying that as long as it's, job related and necessary to protect the employees, the testing is okay. similar to what they said several weeks ago for temperature checks. So temperature checks, we are definitely, if you have the resources to do them, you should try to do them. Testing is going to be a little bit more difficult until the production of tests ramps up, but it's definitely a consideration. Put into place an action plan. If it's similar to when we were first closing down, we first had our first cases of COVID, what do I do if I find someone who's sick? Contact tracing, clean their work area, that type of thing. Determine who they've been in contact with so that you can let those people know that they may have been potentially exposed. Obviously, keeping the employee privacy question or concerns at the forefront. Don't give their names out, etc. Determining when you have an employee who has been sick, determining when to bring them back to work. CDC, again, has some great guidance on this in terms of a confirmed sick worker, bringing them back. There's several different strategies you can go through. The non-test strategy is where you can't get access to a COVID test to confirm that they're negative. You know, have they been symptom-free for 72 hours or more without the use of medication? And has it been at least 7 days since their first exposure to COVID? So there's those things to think about. And can you keep potentially exposed workers at work? This is more important if you are a critical business and you can't afford to lose people. You can keep potentially exposed, non-confirmed, non-symptomatic folks at work with certain precautions such as face masks, temperature checks, etc., sending them home immediately if they show any symptoms. I know there's a lot here, guys. I'm sorry, but I'm trying to get through it as fast as I can. Some other issues that have come up in the OSHA world that may result in OSHA litigation down the road is, should I record or report my COVID cases? OSHA has put out guidance saying, we understand that in non-healthcare settings, non-emergency responders, and non-correctional facility settings, it's going to be nearly impossible to determine whether something is work-related. That signals to us that they are not expecting people really to record these on their logs or to report them if you have a hospitalization or a fatality. They're not going to be able to figure it out either. So if you have any questions about that, please come back to us. Separate and apart from the whistleblower issue is OSHA complaints. We've been helping clients respond to a lot of complaints from employees saying PPE is not available. They're not doing what they can to protect us in the workplace. If you're following the CDC guidance, if you're providing the materials that your local jurisdictions say you should, we've been getting responses from OSHA saying, thank you very much. This file is closed, move on to the next thing. I'm not going to really address these last two because I need to get to the last slide that I have. But, if you have anybody calling you, an agency, whether it be OSHA, or an attorney general or a local health department, reach out to us. We can help you develop a response for them. Finally, you may have heard some about workers' compensation. It's very similar to the question as to whether an OSHA case or a COVID case in the workplace is recordable or reportable for OSHA purposes. There's a difficulty in determining whether it was work-related or gotten in the workplace. A lot of states are changing this. I've got a list down at the bottom as to who's changed it. Just so you know, in Illinois, there was just today or yesterday a temporary restraining order on Illinois' change in the law. But what these states have been doing is taking certain categories of people and making them rebuttable presumption that any COVID was obtained in the workplace so that then they can obtain workers' compensation benefits. Now, I'll leave the question kind of out in the air as to whether this might ultimately be better for the employers because it protects them against damages in tort, damages and other types of liability that may be many, many times workers' compensation benefits. So that's up to you guys, internally to determine whether you want to accept these cases or not. With that, I'm done and pass it on.
Great. Thanks so much, Patrick. Really appreciate it. I've got the opportunity here to read you all the CLE code. So if you are listening and need CLE credit, if you take this down, the CLE code today is SS for Seyfarth Shaw, SS SS8831. SS8831. There'll be a copy of the CLE attendance and evaluation form circulated after the presentation. You can fill it out, scan it, send it in, and if you would prefer to respond by email, just let us know on that as well. All right, so Lynn and I are going to take you through the employment litigation. We've got sort of a list here of the hot topics that we're going to cover briefly. Obviously, this can be like each of these segments could be a webinar all in and of itself, so we apologize for going quickly, but we thought this was something that was important to include. Lynn and I, prior to today, we sort of did a temperature check of the plaintiff's bar to figure out what's happening and what they're doing. You'll be happy or probably unhappy to know that there's much activity and much preparation. All of them are talking about class claims. These are faster and easier for them often to bring, result in quick settlements, and supported obviously by large-scale policy decisions. Things like Lynn will talk a little bit about wage and hours, a very fruitful area for them. You know, there are many claims out there already, many, many more likely to come out of the COVID-19 adjustments. Also, they're reporting many individual claims. We see them in the context of layoffs, furloughs, and now return to work. Lots of age claims, disability claims. Their view is that they're going to be very busy as we come out of this. Unfortunately, that means so will all of us. We are at Seyfarth keeping a running list of all of the reported workplace cases on COVID-19. They are listed by subject matter and the plaintiff's lawyers. It's actually a pretty interesting list. We're updating it daily. We don't want to send it out to all of you because not all of you will be interested, but if you would like to get a copy of the list, just let us know in the chat box and we'll send one out to you. So the issues in front of us are the ones we know. There are some new issues. You've heard them talked about here, testing and distancing, things like that. But all of them really are arising in the context of laws we are familiar with as employment lawyers. So we'll walk through sort of the hot areas for you to be considering. So this is the sort of first group, discrimination and harassment. Lots of data is beginning to emerge on the increase of these kinds of claims. We looked at something from the New York City Commission the other day. They've recorded 250 reports of harassment and discrimination over the last 2 weeks. Out of those, over 40% identify incidents of anti-Asian harassment or discrimination. We're seeing more and more of that. We're also seeing, interestingly, that both the federal agency, obviously the EEOC, but state and municipal agencies are issuing guidelines and legislation. New York State and New York City both issued some in the last week or so. They're very interesting and sort of really refine what they're expecting coming out of our compliance around COVID-19 issues. All of them are really talking about the fear and stigma that surrounds COVID-19 as fueling a lot of issues. That's something we'll talk about here a little bit, but something I know that you're all aware of. We're seeing both disparate treatment claims, but also disparate impact. So just for those of you who maybe haven't thought about disparate impact for a while, because we're very used to disparate treatment, right? I've been treated differently because I'm in a protected class. Interesting around disparate impact, if you'll recall, that's when there is a large-scale policy, right? It's a neutral policy that is applied across a workforce. It can be on attendance, it can be return to work, it can be a furlough, anything like that. And that can result in claims because they impact a protected category. So we're anticipating a lot of action in this area, particularly around issues of age, gender. So what you're going to want to do is work with your employment counsel. If you're having a large-scale decision like that, get them involved. They want to do a quick adverse impact review before you actually begin a furlough or layoff. And again, think about it when you have return to work. It may come across at that point as well. Everybody's reporting a particular amount of interest in age, gender, disability, race, pregnancy claims. Interesting, people who both want to come back and don't want to come back, and raising issues of discrimination. So remember that this entire area really requires some very clear mitigation strategies, but a lot of it is really sticking to the basics. So you want to document your actions. Your business reason is the thing that has to be supportable. So when you're making decisions about who to furlough, who to lay off, who to bring back, what accommodations are needed, make sure that you're documenting and your business reason is clear. It is a time to look at anti-discrimination and anti-harassment messages and policies. So we sort of feel like we just came off of this where everybody revised their training, everybody got their policies up to date. Go back and look at those. If you weren't someone who looked at your training and your messages, look at them now and make sure that they are being reinforced. And as you're going out, as we talk to our HR people and our frontline managers, the thing that we're seeing over and over again in these early claims and complaints is presumptions and stereotypes about people. This person would probably prefer to be laid off because they're older or because they have a disability. I don't want to bring that person back because I'm afraid that they might be subject to, maybe they're pregnant, maybe they have a disability. So anytime you hear someone in HR or frontline management moving for an employment action based on a presumption or a stereotype, that's when you want to be careful. It frequently leads to claims. I also wanted to spend a couple of minutes on harassment. We're sort of used to making sure that our supervisors are not harassing workers. Here, again, the harassment is likely to come up around this whole issue of fear and stigma. But the other thing, just to remind yourself, because sometimes people overlook this, is coworker harassment. So we as employers need to make sure that employees are not harassing one another. So be careful of that as you're going forward. Just a moment on retaliation. Retaliation claims are sort of the bane of an employment lawyer's existence. Frequently we'll win on discrimination cases, but the retaliation component can be difficult to defend. Here, in each of these cases we've looked at, there is a claim for retaliation. I was selected for this because I raised a concern or because I said to someone that this was a problem. Anytime there is a complaint, you may have a claim of retaliation. So again, in terms of mitigation, you want to ensure that the complaint and grievance reporting mechanisms are fully operational. So you probably all have hotlines or may have helplines of some sort of reporting. Make sure, go back out to your people, tell them that those complaint lines are in existence, make sure they're being monitored, make sure that people who are answering them or investigating them understand some of the nuances that are coming out of this COVID-19 environment. It is a difficult environment, and the patchwork of laws and regulations and guidances that are being developed are different for a lot of frontline HR people. And of course, you're going to update your policies, your training, we talked about that. And then anytime you have a termination in particular, make sure the HR/ER person is tied into that. So in case there are issues, maybe a complaint has come to them, everybody's talking to each other before you actually make a decision would be very helpful here. And then lastly, before I turn it over to Lynn, I want to talk a little bit about disability and leaves. It's interesting to us because as we worked with HR communities and employment lawyers before all of this, one of the most complex areas for people was the interaction between the ADA and the FMLA. And now that has just become 3 times more complicated because we've added the FFCRA to that in addition to everything else. So if your employer is under a certain number of employees, you know that you've got paid sick leave, then you have the FFCRA leave, you've got FMLA on top of that, and then on top of that, you have ADA issues. So be very careful here. Again, there should be special training for your HR people. If your leaves are outsourced, if you have outsourced leave management, make sure they're attuned, make sure they are communicating with your HR people. We are in a brand new world around disability and leaves. Now, what we know, again, from the plaintiff's lawyer is they're thinking about a lot more regarded as claims. So you may recall that the law protects not only people who are disabled, but people who we perceive or are regarded as disabled. So that may be someone who has a health condition that they perhaps don't consider themselves needing special accommodations, but you may have a frontline manager acting out of what could be very good motives, trying to give that person accommodations or furlough them. because they are regarded as. So again, be very careful there as you go forward. Interesting discussions out there, and we're seeing this. I've got 2 complaints right now on this evaluation of accommodations. So new accommodations being needed. So this whole thing of, you can't do remote work because that's too hard for us to accommodate. Well, you can make an argument that we've all seen that remote accommodations work. And so is that an area we're going to see a lot more activity? The other thing I think is really interesting is, are the accommodations that are out there still appropriate? If employers, particularly smaller employers, have tremendous financial burdens right now, are the accommodations that were not a significant hardship before the period we're in now, are they now a significant hardship? And again, is COVID-19 a disability, and how does that work through? We're all going to have to answer that really state by state as we all work this out. So again, just in this area, mitigation strategies, education of your ER and HR people and frontline managers. We say this all the time. It is so important right now, particularly in this area of disability and leaves. Make sure you have a formalized process in place for accommodations. That's going to keep people from tripping up around these new laws, and understanding the overlap of all of these various statutes to make sure your employees are being given what they deserve under the law. And I'll turn that over to Lynn. Lynn, to you.
Thanks, Lisa. It should come as no surprise to you that the plaintiffs' lawyers are licking their chops about the up and coming wage and hour litigation, and specifically the opportunity to bring class actions for wage and hour litigation. And I think some of the things that are happening is that decisions about how companies can address COVID-19 and the financial issues that arise from COVID-19 are being made in the boardroom or being made by business folks without consulting you guys, the in-house lawyers, who would certainly issue spot some of these right away. So let's talk about some of the things that you need to be wary of and traps that you might fall into. So you're having financial problems. If you reduce the salary level of exempt employees below a certain exemption level, you may lose their exempt classification. And by losing their exempt classification, you're now going to have to pay them for overtime. You're going to have to pay them for every hour worked. You're going to have to keep track, et cetera. And so what are those levels? Well, right now, the federal exemption level for salary is $35,568. And so if somebody was making $36,000 as an exempt employee under the federal law, if you reduce that even by $1,000 or $2,000, all of a sudden they're no longer exempt under the federal law. And we know that there are various state laws, California and New York, for example, where the threshold is even higher, so that people making less than $54,080 in California, if you reduce their salary so that they're below that threshold in California, all of a sudden they're non-exempt. And that comes with a whole host of expensive and administrative things you have to deal with. What else? A number of CEOs and boards are saying, I have a great idea. Let's take all of our employees and we'll have them only work 20% less time, and we'll pay them 20% less. And that seems like a great result. The problem with that is that under the salary basis test, if people's hours are tied to their wages, you might very well lose their exemption as well. So it's okay to reduce somebody's compensation by 20%, but you can't reduce their duties by the same commensurate level, because then it becomes clear that you're reducing their salary in connection with a commensurate reduction in duties, and therefore you're undermining the salary basis of their exemption. Here's the one that really is coming up the most, though. When you furlough an exempt employee, most of us know that even if somebody works 1 hour in a particular week, if they are an exempt employee, they get paid for the entire week. So, for example, suppose you furlough someone in the middle of the work week on a Wednesday. You have to pay them for the entire week. And if you're only paying them from Monday through Wednesday, well, you're undermining the salary basis and you're undermining their exempt status. And you may very well see a class action for all those days that you didn't pay folks during their work week. The other problem is that what if you furlough someone and they're an exempt employee, but you're still asking them to answer emails every now and again, like, oh, Susie Jones, can you please tell me where the files are on this and such and that and such? And can you tell me what was our practice for this and such and that and such? And so, in effect, Susie's on furlough, but she's answering emails and she's actually working, and therefore she's entitled to pay for the entire week. Even if she only answers an hour's worth of emails, if she's exempt and you don't pay her for the entire week, you've undermined her salary basis. And that may not be a lot of money for one person, but if that's happening for a number of people, as we know, those class actions can add up quite quickly. How about duties dilution? Okay, so suppose you are an exempt employee in a retail establishment and you manage a number of employees, but now you're returning to work and you're going to spend 50% of your time, or more than 50% of your time really, doing non-exempt duties, like working the cash registers because a bunch of folks are sick and you need somebody to ring people up, or going around sanitizing, or going around stocking shelves because either you don't have enough healthy employees to do the job, or there's just too much going on and you want to jump in and be a team player. So you just have to be really careful about duties dilution, because as we know, one of the ways exempt employees are judged is by, are they doing more management work than non-exempt work? And so what, under the federal law, it's usually more than 50% of the time, are they spending more time doing management work and exempt duties. And once you get into a calculation where managers are actually ringing people up, sanitizing, stocking shelves, all of a sudden you now have a claim that they're no longer exempt and they're entitled to overtime and a number of other administrative things. So be very careful. The other thing that we've seen a lot of during the COVID-19 era, as we'll call it, is off-the-clock or hours worked claims. And I like to call this our new donning and doffing claims. And I like to say donning and doffing because there have been a number of wage and hour class actions on this issue of, if an employee needs to put a particular outfit or suit or uniform on, they need to be paid for the time that it takes for them to don or doff their work clothes, right? And unrecorded time by one person may not be a lot, but if you've got hundreds or maybe thousands of employees that have unrecorded time for donning and doffing, that can be quite a large class action. So in the COVID world, our donning and doffing cases come from time spent in activities directed by the employer, like screening. They're coming to work and you're asking them to take their temperature before they can start work. Now, maybe that's only 2 minutes to take a temperature, but what if the employee has to stand in line for a half an hour to get their temperature taken in order before they can start work? Well, that's a half an hour that they're going to need to be compensated. How about if they have to spend additional time now cleaning their workspace, sanitizing their workspace, and sterilizing anything that they use to serve customers or to do their work? Again, that's probably not de minimis. And if it's not de minimis, then employees need to be compensated for that time. Now we may see employees who need to be compensated for work related to putting on face masks, changing face masks, or cleaning face masks or other personal protective equipment. Finally, think about it. There may be new ways that people are learning to do business as a result of COVID-19. Let me give you an example. We've seen a lot of situations where retailers are saying, okay, we're not going to use credit card holders to have people pay for their products anymore. We're not going to use PIN pads anymore. We may use some other way for getting people to pay for the products that we're selling. And there may be new software that gets rolled out or new equipment that gets rolled out so that customers can come in and pay for goods in a contactless way. So maybe there's a period of time that each and every one of these non-exempt employees has to spend learning a new way to work under COVID-19 and training on new software or new hardware. All of that time, ladies and gentlemen, has to be compensable for your non-exempt employees, or you will certainly see a class action for the time that they spent that was not compensated. Finally, we expect to see some class actions based on some sort of state-specific traps. As we know, the federal government has wage and hour laws, but each state has unique wage and hour laws that we have to try to keep track of. Each state has its own meal and rest break laws. Sometimes people may say, well, in this new COVID-19 era, I can't really take my break because I can't go sit in the break room because then I won't be socially distant with other people. So you need to pay me for that time period. Or it's a class action saying you didn't provide a space that was appropriate for them to take a break in and safe. Or they say, I'm sitting at my desk eating my lunch and I keep getting interrupted because people think I'm open for business. And so my breaks are getting interrupted. You didn't give me a full break, and therefore I'm bringing a class action for that. How about this? I can't go to the break room for a break. I have to go outside or go eat in my car, and therefore I don't have sufficient time to go out, sit in my car, get back, put on my personal protective equipment, so you're not giving me sufficient meal, rest, or break time. Another problem or litigation that we may see is that commission plans may be changed midstream. Let me give you an example. If you unilaterally change a commission stream, if your commission stream always said, dear salespeople, you will receive your commission on the sale of that product as soon as we get an order in the door. Now, all of a sudden, everybody's canceling 90% of their orders for your product because they don't need them anymore in this COVID world. And you say, well, we used to pay when the orders were made, but now we're going to only pay commissions when the orders are delivered. Now, all of your employees have been subject to a unilateral change, and 90% of their commissions have just gone the way of all flesh. And you can expect to see a class action for failure to pay money earned under a commission plan if you unilaterally change it mid-year. It's really just a straightforward breach of contract claim. Finally, some states are going to require you to reimburse employees if they've had to work from home and use their cell phone, if they've had to buy a computer or buy a computer monitor or put a printer at home. California, for example, is one of those states where if you require an employee to work from home, you need to reimburse them for anything that they've purchased attendant to that work remotely. So a couple quick mitigation points. Pay attention to the salary level, the duties, and the timing of your furloughs for your exempt employees. And please don't tie any salary reductions for exempt employees to hours worked. Make sure you're recording and paying all non-exempt employees for all working time and all time preparing to work, like those donning and doffing cases. Keep an eye on your commission plan, read it and read it again. If you've promised certain things to employees and you make a unilateral change, you can expect them to bring an action for it. The last topic I'm going to cover pretty quickly is the impact of COVID-19 on jury trials, since that's what I do mostly. We're going to see impacts practically and emotionally. As my colleagues have said, we're doing a lot of depositions, mediations, oral arguments by video conference, and it requires a different skill set for sure. You can pound the table all you want in your own dining room, but it's not going to have a lot of effect. And maybe that's good, maybe it's not. You just really have to hone a different skill set to be effective from your dining room. But on trials, how soon are we going to be able to start having trials, jury trials? And what are they going to look like? Well, I think we can guess we'll probably have jury trials sooner in Georgia than we will in Massachusetts. Some states are going to open earlier than others. And I think we just need to think about our jury pools as we do go to trial, because every single person on the jury is going to be touched in some way by COVID, whether they were furloughed, whether their family was furloughed, whether they got sick or they knew somebody who was sick, whether they had an essential job or not. And I think the views about you as an employer may vary a great deal due to the geography, whether people really think the business interruption was necessary, or was it overblown? You know, were they the protester that said, I want to get back to work? Or were they the person that said, don't you dare bring me back to work? The views on employers by jurors may vary due to their political leanings. You know, do they think that big companies received bailouts that should have gone to poor plaintiffs or other working individuals? And the jury decides, okay, I'm going to reallocate myself. I'm going to take the money back from these big companies and give it to the poor plaintiff who's suing them. And finally, the views of employee rights in these employment jury trials may be impacted by whether the juror was an essential employee on the front lines working for the last, 2 or 3 months during the shutdown, or whether they were working from the comfort of their home and doing a very different kind of a job. So think about that as you approach jury trials and as we try these kinds of cases that we've been talking about today, because I think we have a whole new set of juror influences to think about. And with that, I turn it back over to Lisa.
Great.
Thanks.
Thanks, Lynn. Thanks, everybody. We really appreciate you joining us today. We have a couple of questions. We're out of time, so we'll be responding individually to you. Thanks again. We'll send out the presentation and the recording. Everybody have a good rest of your day and a safe weekend. Bye-bye.
This concludes today's webinar. Thank you for attending.